Well, hello and happy Monday night, everybody. Sorry this ended up much later than I expected it to be. I thought I would be home and all ready to go like an hour and 15 minutes ago, but that didn't seem to happen. So, oh, sorry, my device going off. So, anyway, I'm sorry for making you guys wait, and I hope it's not too late for everyone to be able to join. But here we go. When this case, and I'm gonna kind of ignore comments until the end, just so I can get through my notes and make it all make sense without interrupting, because you all know I get sidetracked. So, when this case was first filed, and it was filed 10 days after the New York Times article hit, many of us were drawn to it, especially those of us who normally wholeheartedly support women. We felt a certain way, especially those of us who didn't know anything about Justin Baldoni or Jamie Heath or Wayfarer or any of that. 17 days later, the counter lawsuit came with screenshots galore. And we said, uh-oh, have we been lied to? More filings came, and we devoured them all, determined to suss out the truth. Screenshots, because they're pictures, really are worth 1,000 words. And they just kept coming. And they've kept coming all the way up to the great unsealing we just had. When all of this began to happen, the claims against the New York Times was my Roman Empire. Hey, Ricardo. Thank you so much. He says, hi, Miss Cassidy, and hi, lovelies. Happy FBL Day. That's every day, isn't it? Yes, the chat is too distracting sometimes because you guys are also interesting. So I always feel bad when I don't look, but I have to do that or I will just keep losing my place. But I will happily chat with you at the end. So back to this. So why was the case against the New York Times my Roman Empire? It's before we knew about Van Zandt, but we knew that something was wrong because the New York Times had declared fair report privilege for their thousands of pages of texts and emails. Why? Why did that bother me so much? Well, those reasons will be explained in a moment, but it's one of the most important points of this whole thing. Why are these thousands of pages of text and emails a problem? There were also references to other documents, and that never sat right with me. It went hand in hand with a huge question of where did those documents come from? The New York Times said they were from a subpoena, but there was no lawsuit to be found. When Blake's lawsuit came 10 days later, it said that they were found by a subpoena, but the lawsuit had just been filed. So what's subpoena? Then Leanne discovered the problem with the metadata, that those screenshots that the New York Times had posted the day after a CRD complaint was filed, but we still had very little information about all that in the beginning. But Leanne found the metadata showed that the New York Times had these pictures way back in October. So a lot of us started to see a problem. October was months before there were any accusations at all to be found anywhere of sexual harassment. It began to look like a premeditated firestorm on Wayfarer, and and that the New York Times was up to their neck in it. At the same time, New York boasts the highest privilege for press in the country. We're familiar with circuit splits, but this is beyond that. They're not only different from the rest of the circuits, but they're different from the other states in their own circuit. Through the years, it's been the New York Times that has been driving that privilege higher and higher. They've recently found a way to exercise that privilege to make it apply to any other state that dares bring a lawsuit against them. They say that it's to equal things out. But when you are the only state that's different from all of the other 49 states, why should they adapt to your way? Now, when I talk about this, I'm not trying to chill free speech. I am not against free speech. I operate my channel thanks to free speech. I'm very fond of free speech. I defended my subpoena with the laws of free speech. This is about New York's fight to not have to answer to any of the rules that the rest of us do. The other states' protections and the Constitution's protection are very strong, as they should be. But New York has arranged things to be absolute privilege. In my opinion, absolute privilege should not exist in any sector, anywhere, not just within freedom of speech or freedom of the press. Because then, well, like in this case, we end up with a reporter that's ambitious to score another success, and she's permitted to stomp all over other people's rights with zero accountability. I say that's taking things too far. This is part 1 of 2, where I will discuss my opinion of why I think that Wayfarer should appeal and why I think this case needs to go all the way to the United States Supreme Court. Now, this is a very difficult task. In fact, it's nearly impossible. Why? Because we're talking about a state's laws, and the Supreme Court doesn't get involved in that. Every state has their own constitution, and it is based on the U.S. Constitution. But that is a right that the U.S. Supreme Court recognizes that the states have. States are permitted to have constitutions that allow more protection than the U.S. Constitution does. They can't do less, but they can do more. So it makes this a problem. The U.S. Supreme Court has turned down many cases like this because they recognize a state's sovereignty and they do not get involved in that. So what in the world can we do about that? That's going to mostly be discussed in part 2, and this part dealing more with the article itself and how it stacked up to New York's laws, other states' laws, and the Constitution's freedom. Now, I showed a thing about Ruth Ginsburg in my last live, and I told you that I would show her comment in full because I just kind of summarized it then. Well, this was an interview that she did just a few years before she passed. She made comments about due process, and that's going to play a lot into part 2, due processes. But the comments that she made about that and about the person that's being accused really stood out to me. This was an article, as you can see in the title, it was about Me Too. It was about other things, but that was the big topic of the conversation. And one thing I noticed about her comments, here she was, a woman who had spent her entire working career fighting for women's rights. She got to the highest court in the country She became a Supreme Court justice, where she continued to fight not just for women's rights, but for anyone or any class that was discriminated against. She fought for their rights. And I realized what a contrast there is between a real advocate for women and someone who is chasing her own glory so fast and so hard that she refuses to see the truth of a matter. And also didn't stop there, but did everything in her power to attempt to blind the rest of us to the truth as well. The contrast couldn't be more shocking. Ruth wasn't chasing fame and recognition. She honestly wanted things to change. Her feelings, her motivation came from a good place, and that's the difference. This is the part of this interview that I really wanted to talk about. So she's asked, what about due process for the accused? Because as I said, this was a topic about Me Too and about laws being strengthened and more being done for women. So this was the question put to her. What about due process for the accused? She said, that must not be ignored. And it goes beyond sexual harassment. The person who is accused has a right to defend herself or himself, and we certainly should not lose sight of that. Recognizing that these are complaints that should be heard. There's been criticism of some college codes of conduct for not giving the accused person a fair opportunity to be heard. And that's one of the basic tenets of our system. As you know, everyone deserves a fair hearing. And I thought that was such a balanced response. To understand, to love law means that you love justice. You don't want to just flip the script and say, okay, we're going to go from pushing women down to pushing men down. That's not justice. Justice is about equality. So you can't amp up women's rights by taking away the rights of men who are on the other side of things being accused. That's not justice. That's just flipping the same problem over on its head. The next question was also interesting. Are some of those criticisms of the college codes valid? Because what happened is laws, when the Me Too movement came and things like that started to happen, some people wanted to be on the right side of things. They wanted to do something good. They wanted to honor this movement. They wanted to honor women. They wanted to support women. But things went a little bit overboard on some occasions. And these college codes, for example, might have gone a little bit too far in their attempt to be on the right side of the law. And she says, do I think they are? Yes. And the interviewer said, I think people are hungry for your thoughts about how to balance the values of due process against the need for increased gender equality. And she said simply, it's not one or the other. It's both. We have a system of justice where people who are accused get due process. So it's just applying to this field what we have applied generally. What a good answer. When someone is coming from the right place, their motivation, they're able to see every angle. Their approach is well thought out. It's obvious that they're doing it carefully and considering everything and everyone, not performing to achieve their own personal fame, no matter how many people get harmed along the way. Although they're from different professions, these two women have both received praise for advocating for women, but only one of them, in my eyes, was a real humanitarian. This episode is all about the recent announcement that Wayfarer made about an appeal. Like I said, it's two parts because the next part is a super deep dive into state law versus federal law and the Supreme Court's position on that, as well as the way in which the New York Times has over time built a great wall around press privilege in New York. It's long been known that they stand out. It's long been criticized for operating as if they are their own country and not under the same constitution as the rest of us. That is a huge mountain to tackle. And it's still in the works. I've been working really, really hard on that one. But part one today is much lighter. As I said, focusing on what New York and other states say about the fair report privilege. Sorry, I forgot to advance that slide. This is what you were supposed to be looking at while I was talking about that. Okay, just contrasting the differences in these two ladies. It's a shocking contrast. Okay. Wait, why did I miss a page here? Sorry, guys. I'm on the wrong side of the page. There we go. Sorry, guys. I forgot I added a few pages and they were printed out separately. Okay, we're going to start with New York State's libel law. In my opinion, this law is pointless because, in spite of what it says here, the courts in New York seem to apply a very different standard to their actual cases. They seem to stop here. It says, let me read the first part. It says, privileges in action for libel. A civil action cannot be maintained against any person, firm, or corporation for the publication of a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding, or for any heading of the report which is a fair and true headnote of the statement published. But it doesn't stop there. But it seems like when they're applying the law, they stop it at that a civil action cannot be maintained against any person, firm, or corporation. Because even though the law continues, they stop the cases like this one, normally almost always in the motion to dismiss time period, where no discovery has been able to be collected. People don't get a chance to even attempt to prove whether or not their case is valid. It automatically gets cut off. That's a problem. Though there are exceptions to the privilege in their law and in the Constitution itself, this is the way it happens. And they do this whether the people are public figures or not. Like in this case, they clumped everybody together as if they were public figures. But we have people like Jen Abel, Jamie Heath, that are not public figures. Melissa Nathan, they're not public figures. So why were they considered under the same standards of public figures? That's another bad situation. But look at what the rest of the law says. This section does not apply to a libel contained in any other matter added by any person concerned in the publication or in the report of anything said or done at the time and place of such a proceeding, which was not a part thereof. So there is much more involved in this actual law. Sorry, hold on just a second. I forgot to unmute myself. The intention behind this right, this freedom, it was a means to keep governmental matters transparent for the public. That's why we see that this law relates to what? To government matters. Things like judicial proceeding, legislative proceeding, or other official proceeding. Proceedings are government matters. That's a very important point here, though. All of these things listed here are not only governmental, but they're also all public. These are all things that the government has well established that we as the public have a right to have access to. The press serves the purpose of attending these public proceedings or reading the public documents from these public proceedings and acting as our eyes and ears and relaying the information accurately and fairly to the public. Why is that? Because we have a right to these things, but we don't have time every day to run to watch every single proceeding or listen to every single proceeding or the ability to access every single document. That's the press's job. They do that, and then they make that information available to us. That is why they're protected, because they are filling a very specific role that keeps the government transparent. Now, the United States Supreme Court has made a distinction clear in many cases that the press is not some special group that has special access to anything and everything that it wants. They are members of the public, just like us. We're going to see a case that talks about that in just a little bit. But another thing about journalists and news media is that they're supposed to be neutral. It's different than editorial sources that must be clearly distinguished as editorial. If you notice in the newspaper, whenever there's going to be an opinion article out there, it's labeled clearly editorial to let people know this is not a neutral news report. This is an opinion piece. They are very distinct and different. It's not news. It's opinions. Those of us who are part of that part of reporting, you might say, we're more free to express our opinions on things. This is very important. This is why I have always clearly distinguished myself as a content creator, sharing my opinion for entertainment purposes and not as a journalist reporting the news. It's a slippery slope for a content creator to call themselves a journalist, because especially if they're sharing opinions and speaking on topics that are not from recognized sources, that are not covered or that are covered under fair report privilege. So there's a responsibility with claiming to be a journalist that's reporting the news, like the New York Times. I don't make that claim. I don't say I'm neutral. I am not neutral. I am very opinionated, and I talk about my opinion, and I express my opinion, and I have a right to do that because I'm not under this sort of privilege. I'm under a different privilege. So we're going to come back to that thought more, but this is my first issue with Megan and her article. She's not speaking on a proceeding here, judicial or otherwise. Why do I say that? Because Judge Lyman said that the New York Times article was protected by the fair report privilege. But I say, I don't think so, because the fair report privilege covers what we see here. And she was not reporting on a judicial proceeding. As we've seen, that's what fair report covers. And it has been extended to include documents from those proceedings. So in her original article, and I want to shout out, I got the screenshot from docketupdates.com, and I want to shout them out. I think most of you already know about that website and what it is. We have Carol there who works tirelessly to keep us updated on everything that comes out. She has all of the documents listed and any new news. She keeps a timeline. Let me reword that. She's working on a timeline that I'm expecting to be absolutely fabulous. But what she does keep is a calendar right now of important dates to keep us aware of what's happening. But this was something that she has on that site, and I thought it was kind of brilliant because the article did change. There were some changes over time to what the original article said and then what it was changed to later. And this was one that really, really caught my eye because the original complaint said a legal complaint lays out. And a very short time later, it says private messages detail. And I can't stop wondering why. Why would she change the wording in this article? Because the privilege covers legal proceedings. So it would seem that this is a much better word choice if you're actually covering a judicial proceeding, an actual legal document. Wouldn't you want to say that? To invoke that protection. To change it to private messages detail sounds like the wrong way to go if you want protection. Do you see what I'm saying? You saw what the law says, that it covers that fair report privilege covers that. So why would you change these words? It's very, very puzzling to me indeed. We're going to start with that. Let's talk about why I say it's not a judicial proceeding. Sorry, looking at my notes here. Focusing on the fact that she changed those wording. A CRD complaint is not, in fact, a judicial proceeding. It is an administrative process. It has many steps. We can see them here. This is directly from their website. It talks about the steps of it. And it is not considered a judicial proceeding. Why? There's a couple different reasons, but I also want to point out that not only that, it is not public. A lawsuit is public. Things that are filed on a docket of a lawsuit, they are public. Hearings are public. Legislative proceedings, public. CRD complaint, private. All right, that's one of the issues. What else? You have to pass a few steps before it's even sent to the person that you filed against. And even then, when the person has received it, it's only to them, and it is still not public. When you fully utilize the Civil Rights Department, what happens next is they hold an investigation. And after that investigation, they can help you make it into a judicial proceeding. But up until that time, it is not. Here's what it looks like. If their investigation, if after the investigation they do find that there was wrongdoing, there are three options. The first one is that they can help you with mediation. They can set that up. They can hold it. Here's a point too. Mediation is private. It is not publicly filed anywhere. The only time that that will become public is if that mediation leads to a settlement and the settlement becomes public record. So all during this part of this process, private, not judicial proceeding. The second option is also after an investigation, once they've investigated and find there's wrongdoing, they can help you with a lawsuit. Now, all that investigation time still private, still not public, still not a judicial proceeding. It's all still administrative until a lawsuit is actually filed. The third option, and this is the option that Blake went with, she refused an investigation. And instead of an investigation, she requested a right to sue letter. This type of letter is also not public. Not only that, once they issue this letter to you, they do not perform any more functions for you. So there is no proceeding at all happening. You have said, I'm going to sue. I don't want an investigation. They are not performing any kind of proceeding for you at that time, not even administratively anymore. There is nothing happening until you take that right to sue letter and you file a lawsuit in court. That lawsuit becomes a judicial proceeding. That lawsuit becomes public. But in this time between receiving that right to sue letter, when the CRD is no longer performing anything for you, until you file that lawsuit, there's nothing happening on your behalf anywhere. There is no proceeding. Now think about the timing of that. Blake got her right to sue letter, and she filed her lawsuit December 31st. So the New York Times article came out during a time where there was no proceeding, and there really was nothing public. So how are they invoking this shield, this protection? Sorry, I'm checking my notes to make sure I didn't forget anything. And they can say, well, if someone is planning a lawsuit, it's covered. But how does that work out? How many times have you heard of someone threatening to sue someone else and they don't follow through? So imagine you tell the newspaper, oh, I'm going to file a lawsuit, and they put out a big old story about it, and then you change your mind. Then what? That's a ridiculous thing to say, that privilege is there because you've said you're going to file a lawsuit. That's like saying, I'm going to file my taxes as married because I applied for a marriage, what do they call a marriage license? You're not married yet. There's no marriage. It doesn't exist. There's intent to, there's a license so that you have permission to do it, but you are not married. You cannot file as married until that license is officiated and it's filed. That's the rules. So that is one of the big questions that I have, because while there was no proceeding happening anywhere, this article had 10 days to bounce all around the globe and claiming fair report privilege on a judicial proceeding that did not yet exist. Speaking of globe, let's take a look at how this is viewed around the globe. Here we see the Reporters Committee for Freedom of the Press. Now they're reporting here on a win in a federal appellate court. This was a fair report privilege. And so they're talking about that here. And what do they say? When it comes to freedom of the press, there are some limitations to the reach of that privilege. For example, the publication of an unofficial, non-public report that contains defamatory statements will not generally be privileged. What are we talking about here? We're talking about a CRD complaint that is not a public report. It is not covered by privilege. In Wynn versus Smith, The Nevada Supreme Court held that confidential documents are not protected under the state's fair report privilege. It's supposed to be public. That is the point. Does the press have access to things that are not public? We're going to see what the US Supreme Court said about that. So in this situation, this man, Steve Wynn, who was a Las Vegas casino mogul, someone wrote an unauthorized biography about him. The book had some defamatory information about him, linking him with organized crime. It mentioned as a source a confidential Scotland Yard report. The court ruled that this was not an official action or proceeding, and so it was not subject to the fair report privilege. Allowing the privilege to cover confidential reports would bring to light information that the government had no intention of releasing and which could be used as a powerful tool for injury. Isn't that what we saw happen here? The government was never going to release her CRD complaint, ever. No intention of releasing it. And what happened? It came to light and it was used as a powerful tool for injury. But according to the decisions in these cases, they said there's no privilege over those things because they're not public. They were not meant to be seen by the public. So what that says to us is that if there is a public reference to information contained in a court document that is not under seal, that is protected. If it's sealed, it's a whole different story. All right, sorry, I'm reading my notes here because I don't want to miss anything. All right, now, have I missed a page? Sorry, guys. I'm really, really tired. I had a super, super long day, and I had some medical procedures done as well, so I'm not at my best. So bear with me for just a moment. Okay, we saw in this case that there were redactions. There were things that were given a special privilege. There was the normal privilege that's always afforded in courts, but there was the first hearing we ever got to listen to was a hearing where they added the attorney's eyes only privilege. Additionally, on top of the already protected stuff. We didn't get to see a lot of things until what we call the Great Unsealing. Now, if a reporter looking at these documents was able to make a connection and say, I know who this is, although they were still redacted, could that reporter have just made an article and freely put those names there? Of course not. This is the kind of thing we're talking about. The government, in this case, the judge in a federal court labeled these things as confidential. The public had no right to see them. If someone unveiled that, they would not have been protected for doing that because the government never meant for it to be seen. So that is the principle here. If it is public, that's the protection that the press has to report on these public things. Now, looking at the Tennessee, this is another state. So I'm just showing you kind of around what other states have determined. So in this case, they ruled the Tennessee Supreme Court ruled about the fair report privilege that it does not apply to a non-public one-on-one conversation between a newspaper reporter and a detective of a county sheriff's department who also served as the public information officer for the sheriff's department. So here was the situation. This detective had been the one that was decided by the department that he was going to be the spokesperson to talk to the press. Did that mean that he could say whatever he wanted and that a reporter could report whatever they wanted? Here, this reporter, in a developing story, interviewed the detective. It was not a public interview. It was a one-on-one conversation. And defamatory statements were made by this detective about this Todd Burke person. Well, he took him to court. And the newspaper who printed that information that they had gotten from this one-on-one interview that was not public, they moved for summary judgment and said, hey, I'm a reporter. We're a newspaper. We have fair report privilege. But they said this privilege protects persons and organizations that report on official acts and proceedings from defamation claims, so long as the reports are fair and accurate. Mr. Burke said, wait a minute. And they granted summary judgment. He said, this is non-public, one-on-one interview. It was not official, and so privilege doesn't apply. The Court of Appeals reversed the trial court's decision and held that the private interview was not, in fact, an official action because it wasn't an official proceeding. It wasn't a public meeting, and therefore it did not meet the scope of the fair report privilege. So the approach that the Tennessee Court of Appeals has consistently taken and held that the fair report privilege applies only to public proceedings or official actions of government that have been made public. The Supreme Court explained that limiting the fair report privilege to public proceedings or official actions that have been made public advances the purposes of the privilege. Remember what they're there to do: to keep the government transparent, to report to us what's happening in public proceedings, which are enabling the press to be the eyes and ears of the public and facilitating public supervision of official actions and proceedings. So that is the standard. That is their job. They are not supposed to go beyond that. And so when they do, they are no longer protected. It's like an umbrella. An umbrella, when you hold it over your head and you stay under that umbrella, you can stay out of the rain. But if you step out from under that umbrella, you're going to get rained on. That's how this protection has been illustrated, that you have to stay under that protection. And when you venture out, you're fair game. So here we have yet another. And we're going to go through quite a few of these just to keep stressing this point, that it's not some rare little thing that I dug and dug and dug for days to find. This is the standard out there. So this is the National Scholastic Press Association. So this is an educational organization. Here's what they say to journalism students when they're explaining to them about what the fair report privilege involves. They say the information, number one, must be obtained from a record or proceeding recognized as official. News reports based on judicial and legislative documents or proceedings will generally be privileged. Two, this is another issue that I have with this situation, and we're going to dive much more into this today. The news report must fairly and accurately reflect what is in the public record or what was said during the official proceeding. News reports that provide an inaccurate or misleading account or, this is so important, that contain extra information not found in the official record might fall outside that privilege. An Illinois court recently ruled that a newspaper was not entitled to rely on a fair report defense when it erroneously used a yearbook photo of a high school honor student and star athlete for an article about the drug arrest of another student with the same name. Whoopsie daisies. The reporter claimed that she had been provided a data sheet by the police that included the erroneous yearbook photo. Did that save her by saying, well, the police gave it to me? No. It wasn't part of the official record, the public police record. It was something extra. So it was not an article, it was not an accurate report of what was in the record. It was the wrong person. Okay, next we're going to move on to the Free Speech Center. Lots of organizations speaking on this. So let's see what they have to say about it. They say statements made during the official affairs of the government or governmental meetings. That's how they define what is covered. If the content of the reporting deals with a matter of public concern and is a complete or fair abridgment of the government action. For example, if a reporter attends a city council meeting and a city council person utters a defamatory statement, the reporter generally may print the defamatory statement of the city council person. Why? Because he said it in public. He may be in trouble for making the defamatory statement, but because he made the statement in a public place, the reporter who reports on that is safe, is covered by this privilege, whereas that last reporter was not covered because it was not a public proceeding. The privilege covers the media's accurate reporting of official statements by government officials made at government meetings or sometimes made in less formal ways. However, the fair report privilege may not cover unofficial one-on-one statements between a government official and a reporter. So not even a government official speaking one-on-one with a reporter can be reported. So what about Blake speaking one-on-one with a reporter? Or Blake's PR person, Leslie Sloane, speaking one-on-one with a reporter in private, not public? What happens to that privilege? Is there privilege there? If not even what a government official says or a sheriff says, if they say it in a private conversation, those are not covered. But what Blake and Leslie say is okay? Really? What is this, that celebrity privilege again? A report of an official action or proceeding or of a meeting open to the public that deals with a matter of public concern is privileged. Plain and simple. We've got more. We can keep going. The Digital Media Law Project. What do they have to say? If I gotta scoot my microphone closer because this is small on my screen. If you relied upon an official public document or statement by a public official for the false information, and you fairly and accurately use the source, the privilege enables you to freely report. What people say during a council meeting or from the witness stand during a trial, or to quote from public records. So you're still safe, even if what you reported turns out to be not true and turns out to be defamatory. If you are just accurately reporting something that came from a public meeting or a publicly filed document, you're protected. The fair report privilege's historic rationale has been to encourage public scrutiny of governmental activities. through fair and accurate reporting of governmental proceedings. So you're covered if, one, your source is an official public document or statement by a public official on a matter of public concern. Public, 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 public. We're just going to keep hearing that word. Number 3, you fairly and accurately portray the information from the document or statement. Sorry, I can't hardly see this. We see the word publicly again. If it's publicly available government records, official government reports, and statements made by government officials. This is really important. Interim and unfinished government records and reports generally are not covered. So Blake's right to sue letter that she got, that had not been investigated. Would you consider that a finished government record? No, because they had not performed an investigation yet. Also, it was not public. And at the bottom, it says the privilege would probably not apply to an arresting statements made by an arresting officer about the facts of the case, where those facts are not recorded where? In the police report, because you can FOIA police reports. You can get copies of police reports. So those are considered to be public. But if the officer says something that's not in that, you are not covered to report that. Gossip overheard on the courthouse steps. It's not an official proceeding. Offhand remarks made by a government official. Oh, sorry, I always do that. There's a little thing on my screen that's covering the end of that, so I can't see. Let me see if I can't see that on my notes. It's really super tiny in my notes. So you'll have to read that part for yourself because I can't remember what it says here. Okay, now we're going to move on to the actual, what the Constitution itself actually says. This is so important. And I want to bring your attention to this website as well. This is an amazing website. I absolutely love it. It is called constitution.congress.gov. The beautiful thing about this is that it is run by the Library of Congress itself. It is the purest source of information on this stuff. The second reason I absolutely love it is it goes through the entire conversation. Not conversation. It goes through the entire Constitution is what I meant to say. And what it does is it puts in everyday non-legalese definitions and descriptions and explanations of what these amendments mean. So if you ever have a question about the Constitution or about one of the amendments and you don't understand it and you want to know it better, I highly, highly recommend this website. I absolutely love it. And like I said, it's written in the kind of speech how we talk to each other every day. It's not something that's beyond our grasp to try to figure out what they're saying here. I really think there's no reason to speak that way. Even attorneys, I hate that kind of exclusive thing. Like speak in a way we all understand. There's no reason to do that. But it shows here, the amendment itself is very plain and simple, very basic. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. That's all it says. That simple. And so the beauty of this website is that it goes in to describe and define and explain what that means from a legal standpoint. And throughout, you can see the little footnotes. It has a huge stack of cases at the bottom, all decided by the Supreme Court. This website, as I said, it's kept up by the Library of Congress. So if there's any new decisions made by the U.S. Supreme Court, they're here putting them in immediately. Any references that are in those decisions, it's all here, up to date, and very, very good to understand. So In the explanation of this, let me see where I have that. It points out some interesting things. And one thing I want to mention is that there is not a single right or freedom that we have in this country that is absolute. When you think about it, not a single one of these things are absolutes, though we have these rights. So, for example, um, liberty and freedom. I mean, that's not like a basic First Amendment right like this, but it's mentioned that you can't infringe upon that. We can lose that if we break the laws, and the government can put us in prison. What else? Things that are mentioned here, for example, freedom of religion. Okay, we have that. But that doesn't mean I can go start a religion that requires human sacrifice, right? Because we can't do that here. So none of these rights are absolute. What else? We have a right to bear arms. But the government still has a right to put rules and regulations on that. For example, they can say that felons don't have a right to carry weapons. They do that for the peace and safety of others around them. They can say that you can't, there are certain places you can't have them. You can't bring them into a federal courthouse or any federal building unless you're the security. They can say, okay, you can have these guns, but you can't have these automatic rifles because they are just far too destructive, and there's no reason you have a need for that. Do you see what I mean? Nothing is absolute. It is the same with freedom of speech and freedom of press. There are rules for all of these rights that you have to abide by. One of the things that it says, now this is the continuation of that explanation of the First Amendment. It says, several Supreme Court holdings firmly point to the conclusion that the Free Press Clause does not confer on the press the power to compel government to furnish information or otherwise give the press access to information that what? That the public generally does not have. This is directly from Congress. The press doesn't get access to something that the public generally does not have. They are not allowed to say it either and still be protected, nor is the press entitled to treatment different in any kind from the treatment to which any other member of the public may be subjected. They're not some elite class that is privileged to get to know things that we as the public don't get to know, because the press are public too. So the court has ruled that generally applicable laws do not offend the First Amendment simply because their enforcement against the press has incidental effects. Okay, here is one of the cases that they cite. It is Saxby versus the Washington Post. Now, this was a case where there were accusations being made by prison inmates that were saying that there was some abuse happening within the prison. And so the press wanted to get in, the Washington Post specifically wanted access to these prisons, and they were denied access. And so they took it to court and they said, hey, we've got freedom of press here. You have to let us in. But what did the U.S. Supreme Court decide? They said that prohibiting personal interviews between newsmen and individually designated inmates does not abridge the freedom of the press that the First Amendment guarantees, since it does not deny the press access to sources of information available to members of the general public, but it is merely a particularized application of the general rule that nobody may enter the prison and designate an inmate whom he would like to visit, unless the prospective visitor is a lawyer, clergyman, relative, or friend of that inmate. So whatever rules apply to the public also apply to the press. So if the press does not have access to certain things, they are also not protected when they discuss these things, because even they shouldn't have access to those things. Newsmen have no constitutional right of access to prisons or their inmates beyond that afforded the general public. The proposition that the Constitution imposes upon the government the affirmative duty to make available to journalists sources of information not available to members of the public generally finds no support in the words of the Constitution or in any decision of this court. Since this policy, this particular policy that the prison used to keep them from being able to just say, hey, I want to talk to this person, I want to talk to that person, without having any right to speak to those person because of these rules that you have to be lawyer, clergy, or a friend, does not deny the press access to sources of information available to members of the general public. They don't have rights beyond the public. What does that mean? It means that they have limits, and that the government has long recognized that there are limits to what the press can do, and that they should never have absolute privilege. They were never given absolute privilege. The government has found ways to limit their protection and what they're allowed. All right, let me come back to this. So that brings me to this big old question that I have. Why would and did the New York Times change the wording from a legal complaint to private messages detail? I'm really at a loss about this, because a legal proceeding is protected, but they switch it over to private messages detail. And to me, that becomes even more problematic. So I want to know what the reason was behind this word change. Did they weigh something out? Did they weigh out that making a claim that this was a legal complaint, when in fact it wasn't, could be bad for them? Do you know what I mean? Is anybody else like so bothered by this? That's one of the reasons I could think of, that they recognize that, okay, this isn't a legal complaint after all. We can't call it that, or we can get ourselves in trouble. I don't know. It's very, very odd indeed. All right. And the other thing is, like, to have the gall to say private messages detail. And what would give them the confidence to just put that out there like it doesn't matter? Like that's a protected thing to report on. And it's the confidence that's been handed to them time and time again by the New York courts, by the New York courts' application of the laws surrounding the freedom of press. That's what has given them this kind of gall, in my opinion. They know that even if they get sued, that it's going to get dismissed long before any discovery can be collected, that they have nothing to fear. But going back to this, now this is the New York statute that is supposed to determine what courts rule in these cases. Let's go back to what it says. This section does not apply to a libel contained in any other matter added by any person. So even if somehow, some way, they finagle to say this CRD complaint, even though it was no longer active, there was no proceeding, it was dismissed when they gave her a right to sue letter and the lawsuit had not started. Excuse me. Even if they say that expired administrative process is a judicial proceeding and so it's protected, what about the rest of the stuff they reported? anything added by any person, we saw how that applied to a sheriff. We saw how that applied to a government official. If it's one-on-one conversation and not a public proceeding, it is outside that privilege. But this says anything added by any person. What else? The report of anything said or done at the time and place of such a proceeding, which was not a part thereof. Like, for example, the things that sheriff said that was not in the police report. Not covered. So says the New York statute. Why do they not hold to the statute when they come up to these conclusions in court? Jordan's question, sorry, I saw that. I do not. It is just me. That's why it takes me so long. That's why I disappear for so long in between things, because I am obsessively digging and digging and digging. This was a lot of this put together on a plane ride and in car rides and all sorts of things. So, looking back at the statute, it does not apply to any matter added by any person, not even Blake. There is no celebrity privilege, Judge Lyman, which was not a part thereof. What did Meghan, thousands of pages to say? These documents, other documents, things we reviewed, things that were not a part of the complaint. How did that slip through the cracks? That's what I want to know. And this is why I think Wayfarer needs to appeal. Because not even New York law was properly applied here. What else? We're going to look at Meghan's what I call hit piece. This was not an article. This was a hit piece. So going back to, let me flip back to the opening page. Where was that? We look at the title, We Can Bury Anyone Inside a Hollywood Smear Machine. Private messages detail an alleged campaign to tarnish Blake Lively after she accused Justin Baldoni of misconduct on the set of It Ends With Us. If you read that title there, does anything in this title tell you that this is about a legal proceeding? That's really important. When you read that, does anything on there say this is from a legal proceeding? No. All right, let's look at the first couple of paragraphs. She starts stating this stuff as absolute fact, when she should have begun this article by saying, allegations made, because at this point, that is all they were, allegations. At this point, we are over a year later, that's all they are. So it should have made clear allegations, that these were allegations made where? If she wants to claim privilege and protection because these are so-called judicial proceedings, she better say that. She didn't. It should have said allegations made in a recently filed, it should have been a lawsuit before she reported on it, and it wasn't. But it should have identified that these were allegations from some type of legal document, but it doesn't. It just starts laying down facts here. Last summer, as the release of It Ends With Us approached, Justin Baldoni, the director and star of the film, and Jamie Heath, the lead producer, hired a crisis public relations expert. She's saying this as fact. These are allegations. She may have looked at whatever she looked at, but how could she just absolutely say to the public that this is factual? This is what it was, Justin and Jamie, and they hired this public relations expert? Was it Justin and Jamie, or was it Wayfarer? Did she have exact proof that this had all happened? Or has she just seen stuff that was handed over to her from Blake? Allegations. All right, what else does she do? We still don't have any idea that this is from any kind of judicial proceeding. During the shooting, she's just spouting this as fact. Blake Lively, the co-star, had complained the men had reportedly violated physical boundaries and made sexual and other inappropriate comments to her. Does she have absolute fact? Did she see an official complaint filed by Blake that these things happen? Was that complaint in a publicly filed judicial proceeding? No, but she sits here and states it as absolute fact. Their studio, Wayfarer, agreed to provide a full-time intimacy coordinator, bring in an outside producer, and put other safeguards on set. Megan, do you know that Justin is the one who hired an intimacy coordinator? He was not asked and had to agree to provide anything. She was already there. But you report this like it's fact because you've gotten information from someone, not officially. It has to be true and accurate reporting. Here's another fail. It is not a public judicial proceeding. She's stating it not as allegations. She's stating this as if she is testifying in court that this is true. I have seen the evidence and this is true. Not only that, it's some false statements here. She stepped out from under that umbrella. And Lyman dismissed the case, saying she was still under it. He missed all of this. And I want to know why. In a side letter to Miss Lively's contract signed by Mr. Heath, the studio also agreed not to retaliate against the actress. She's still stating everything as fact. But by August, the two men who had positioned themselves as feminist allies, guess what, Megan Toohey? They never called themselves that. Justin, not Jamie, had a podcast where he spoke to men about men. He never called himself a feminist. He wanted men to do better. He used his own mistakes from boyhood to adulthood to say, these are the mistakes I've made. This is why I regret those mistakes. This is why I want you men who are listening to try to do better and not make the same mistakes I made. Is that feminism? No. But Megan is sitting here. She knows it all because she's seen all these documents. So she can sit here and testify. That is not your job, Megan, but you do this because you know that in the state you live in, that you are going to be good and overprotected, even if you step out from under your umbrella. Now we finally get, according to a legal complaint that she filed Friday. How do you have access to this, Megan Toohey? It's not public. And because it's not public, you don't have the right to report on this. You should have waited till there was a lawsuit. But you wanted to get ahead of the game. You wanted to be the first to tell the story before anyone. You wanted another Harvey Weinstein Pulitzer Prize award-winning article, and you didn't care about anything else, in my opinion. That's protected because it's an opinion. She goes on. Oh wait, no, we're gonna stop there and talk about something. Sorry, I got carried away and just left my notes in the dust here. Nothing about her language alludes that this that alludes to this being her reporting of a document. This is all like statements of fact based on what she's seen. And she doesn't just say what I've seen. Look what she says in the next paragraph. Her filing includes excerpts from thousands of pages of text messages and emails that she obtained through a subpoena. Oh, really, Megan? Are you stating something truthful and factual here? And what do you know about that subpoena? That's a sham subpoena, and your legal team should have caught that. A bunch of non-lawyers caught that. Then she says, these and other documents were reviewed by the New York Times. That is huge because she separates what was filed from these other documents and says they were reviewed by the New York Times. That is not covered. It is not. I start by saying the CRD is not covered anyway, but even if by some stretch of the imagination it's covered, it's only what is contained inside that filing is covered. These other documents she's speaking of that were reviewed not just by her, but now she's invoking the entire power of the New York Times itself, where they reviewed these. So my impression of this is we have reviewed this as the New York Times, the most prestigious, popular, powerful reporting system in this country, if not the world. We have reviewed this, and I am here to tell you that these are the facts. That is what this article is signaling. This is not allegations were made in a legal complaint filed stating that this is what happened. No, that is not how she presented this. And some of her facts are wrong. All right, what else? Here's what she keeps saying. The documents show. Where do you hear sentences like that? The documents show. Right away I thought of this language that she's using here. She sounds like an attorney giving their opening statements or closing arguments. They tell you about the evidence. They say, this is the evidence that's been presented, and this is what the evidence is going to show. How many times have you heard that in a court session where they say that in their opening arguments? Or they review it in closing statements and say, this was the evidence, and the evidence showed. When have you ever seen a reporter report a news story like this? The documents show. She is absolutely 100% testifying to these documents that were reviewed by the New York Times. This is gross. Shame on you, Megan Twohey. Shame on you, because you know better, but you sit in a newspaper that has time and time again had lawsuits brought and been protected and overprotected beyond what it should have been. That's why you can sit here and speak like this in your articles. Thank you so much, Kyle Atkins, 1977. Hi, Cassidy. You do a great job. Thank you. Thank you. I love doing this. Absolutely love doing this. So I'm always happy when you guys say things like that, when you like it. Okay, it just keeps going. It just keeps going. So, and then this is another thing I think is disgusting. When she mentions Melissa Nathan, how does she introduce her to us? Whose clients have included Johnny Depp and the rappers Drake and Travis Scott. She makes sure to add little tidbits that are controversial that will make her look cringe or discredit her in some way. People have negative feelings. Not everyone. Some people are very pro Johnny Depp. Some people are very anti Johnny Depp. Same with Drake and Travis Scott. But it's just interesting to me that they pick out the most controversial and the most, just like purposefully, to try to make Melissa look bad. But here she goes again. In the following weeks, Miss Nathan went hard at the press. Do you have proof of that, Megan? Is that in a judicial document somewhere to protect you for saying this? Because these are Blake's allegations, but they turned out to be false. She was not able to find evidence that this happened. What else does she say Miss Nathan did? Pushing to prevent stories about Mr. Baldoni's behavior and reinforce negative ones about Miss Lively. Where's your proof of that, Megan? Here she goes again, testifying. The text messages show. That is not how she should say this. The text messages allege Jed Wallace, and now we gotta make him look bad too. Okay, a self-described hired gun. Now she's gonna state facts as if he's already been found guilty of this. This man's case has been dismissed. Is this factual then? Led a digital strategy that included boosting social media posts that could help their cause. Where's your proof, Megan? She's not reporting. She's testifying. But oh my, how the tone changes when she starts speaking about statements from the Wayfarer side. Now suddenly, it's all business. The factual statements are gone. It's all, well, Mr. Friedman wrote. Mr. Friedman said in a statement. Why couldn't she say that about Blake's side? The only facts that the only thing that she speaks as its fact is to say that he accused the actress. The rest of it is just ridiculous. Then after he says the claims are completely false, outrageous, and intentionally salacious with an intent to publicly hurt, she says he didn't address the allegations about misconduct. He did too. He said the claims are false, completely false, outrageous, intentionally salacious. Intent to publicly hurt. Is that not addressing the allegations? Is that a denying the allegations? What else does she say? Then she starts to interpret his denial, that it's only about the media manipulation. And when she says something, when she's quoting Friedman, it's all he alleged that. When it comes from Blake, it's fact. This happened. These people did this. But when it's Friedman, oh, he alleged. This is how she should have been writing the entire article. Sorry, I'm looking back at my notes. Yeah, she goes from reporting what Blake told her to the text show to he alleged. And let's see. By saying that he did not address the allegations, she's steering her readers to believe that. Very few people are going to sit here and think about this long enough to realize that it's her convincing us that he didn't address the allegations and that it's not actually what Friedman did at all. He denied it twice here in these few paragraphs. And this little tiny bit that's in here is such a small portion of his official statement that it's almost laughable. The part that she puts in there. And even more so, I want to talk about that in a little bit in a moment too. Oh wait, did I miss it in the notes here? Sorry guys. I want to look. Okay, I think I did. And I don't want to miss this fact. Oh no, it does come later. It does come later. Sorry. I just didn't want to miss something, but it does come later. All right. Now she's back to stating facts. Totally back to stating facts after she's done with the teeny tiny little bit of his statement that she put in here. That is all allegations and he wrote and put the little bit of descriptive nastiness all over throughout it. Now we're back to the effort to tarnish Miss Lively appears to have paid off. Oh, sorry, guys. More facts. Within days of the film's release, the negative media coverage and commentary became an unusually high percentage of her online presence, according to a forensic review she sought from a brand marketing consultant. Miss Lively, let me stop there and say that it's still stating as absolute fact that there's no way that anyone can objectively say that she's just reporting allegations from a judicial proceeding with zero personal feelings here. No way in this world. And now we get to when she puts Blake in here. Now, how did she say Miss Nathan? She compared him to controversial people when she introduced Jed Wallace, who calls himself a hired gun. Okay, when she describes Blake, Miss Lively, who's married to the actor and entrepreneur Ryan Reynolds of Deadpool fame. What does Deadpool have to do with any of this? At that time, it was a huge movie. At that time, Ryan still had a really good reputation. So they throw that in there. Why? And is close with Taylor Swift. What does that have to do with anything at all, Megan, other than to invoke the Swifties, to tie her to dearly loved people, famous people? Because you know what? When this hit the New York Times, if she didn't link her to Ryan and Taylor, a lot of people probably would have said, who's Blake Lively? But just what a contrast in the way they introduce Blake and Melissa Nathan and Jed Wallace. Now, the other thing is that she makes this statement about negative media coverage and commentary becoming an unusually high percentage. Now, I want to say that I'm just a YouTuber. I have a relatively small channel. But if I'm told something by someone else, like this kind of accusation, that there was negative media coverage, look at this review. I got absolutely attacked in the media. And so I hear this story and they want me to do a story on it. The first thing that's going to come into my head that I need to do is to go look at the media coverage. In fact, When I first heard about this case, that's what I did. And I wasn't alone. A ton of us did the very same thing. And do you know what we found? That from the moment Blake was cast as Lily, people started having something to say. They were not pleased with it. They were not happy with it. They didn't think it was a good match. Then, when they started seeing pictures of Blake filming, the internet erupted. What is she wearing? People started putting on layers and layers of clothes from their closet and doing TikToks. There's there was a million things out there long before any accusation or anything went bad between the two of these people. And if Megan had spent just a couple of minutes of her time to look up what the media coverage actually was, she would have seen with her own eyes that it wasn't anything done by any hired gun or any former representative of Johnny Depp. She would have seen what it was about. Then what happened? The ridiculous marketing that was done by her dope of a husband and herself that was so bad that it made people literally angry. She advertised booze. She advertised her hair care line. They had ridiculous skits where Ryan Reynolds and his mother sexually harassed Brandon. People were turned off by this stuff. There was nothing being mentioned about DV. It was all this other weird stuff. Then she started saying flippant remarks like when someone seriously asks what she, if people needed help, what should she tell them or would she tell them? And she's like, I don't know, location share, give them my number. What a ridiculous thing to say. She should have been prepared for that. She should have said, here's this hotline. Here's this woman's organization. Here's what you can do if you need help. Here's where you can reach out to. But no, she said something so sarcastic and ridiculous that it made everybody mad. Well, the times we live in, it's the age of accountability. Once you do something like that and people start talking, it just explodes. Timothy Chalamet, what's his name? Chalamet? He's got something going on because he made a stupid remark that nobody cares about ballet. And what else was it? Classical music or something? Now he's getting shredded. That's what happens. You say something stupid and hurtful to other people or do something stupid and hurtful to other people, it's going to get talked about, and then everything about you is going to get put under a microscope. This is not something that has only ever happened to Blake, but a few minutes of research would have shown Megan that this is not a factual statement, but she's putting it here. Oh, opera. Thank you, Christina. Ballet and opera, that nobody cares about that. What? Just because you don't care about it. But these are the days we live in. People are angry, people are bitter, all kinds of things. And this is what happened to her organically. But no, she's still here without doing a lick of research. She's stating these facts because her and the New York Times have reviewed these other documents and they know better. She continues. Mr. Baldoni, by contrast, emerged largely unscathed. This month, he was honored at a star-studded event celebrating men who elevate women, combat gender-based violence, and promote gender equality worldwide. We know why Blake wanted this put in there. She wanted that taken from him. What better way than to get this noticed in an article in the New York Times so that people would start calling for that to be revoked? And we know that her and Taylor had nasty little conversations about this honor. We know they wanted that revoked. It goes on Saturday, however, after this article was published, the talent agency William Morris Endeavor stopped representing Mr. Baldoni. Okay, that happened, but now we know a lot more about why it happened, don't we? Now she goes back to talking about Blake. She finally admits here that this complaint is not an actual lawsuit, that it's a precursor to a lawsuit. Right there, plain as day. It's not part of a judicial proceeding. And then puts a really nice statement in full by Blake about what she hopes her legal action is going to do. And that gets put in there. It doesn't get divided up. It doesn't get redefined by Megan. It gets put there in full as Blake said it. But when she talked about the statement that Friedman made, she cut it all up. She broke sentences up to input her little nasty things in the middle of it, her little accusations. She rewrote what his thing said. So we saw how she portrayed it, right? This is all she says of his entire statement. Did nothing proactive nor retaliated. Those are a few words she directly quoted. Another desperate attempt to fix her negative reputation. These claims are completely false, outrageous, intentionally salacious, with an intent to publicly hurt and rehash a narrative in the media. So in between those quoted things are her words, so that she could interpret this and steer it in a different direction than the way he said it. Down again, she's got her own words, her own words, her own words, and then finally, negative and completely fabricated and false stories with media. That's all that came out of that one. Then her words, her words, her words was another reason why Wayfarer Studios made the decision to hire a crisis professional. She didn't let him have his statement at all. Now here's his statement in full. And this is sent to her by Jen Abel, and she says, Megan, please see the on-record statement that must be included in full. She's got pages and pages and pages of her testifying to what she's seen in Blake's evidence. Those few little bits and pieces is all she put in of Friedman's entire statement. Here's the entire statement. If you've never read it yourself in full, I'm going to read it now. It is shameful that Miss Lively and her representative would make such serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives as yet another desperate attempt to fix her negative reputation. This is the part that was totally left out, which was garnered from her own remarks and actions during the campaign for the film. She could have looked that up, like I said, and seen who was telling the truth. She didn't. Or if she did, she ignored what she found, which was garnered. Oh, wait, no, sorry. Interviews and press activities that were observed publicly in real time and unedited, which allowed for the internet to generate their own views and opinions. Why did she leave this out? That's intentional. In my opinion, what she put in of his statement did not correctly represent what he said at all. Then this part she included about the claims false, whatever. And then Wayfarer Studios made the decision to proactively hire a crisis manager. She left this part out, even though she said that they made the decision to do it. Prior to the marketing campaign of the film, to work alongside their own representative with Jones Works employed by Stephanie Jones due to the multiple demands and threats made by Miss Lively during production, which included her threatening to not showing up to set, threatening to not promote the film, ultimately leading to its demise during release if her demands were not met. None of that made it to the article, even though it's absolutely important and extremely interesting. That tells me if you have a real journalistic mind, if you really want to get a story out there, like if someone has told me something like what Blake has told, and then I get a statement like this, my mind is going to go crazy. Wait a minute, these are conflicting stories. I got to find out what really happened here before I print a word or repeat a word. But she just she cuts this out, doesn't put it in the article, and ignores it. It was also discovered that Miss Lively enlisted her own representative, Leslie Sloane, with Vision PR. They completely leave Leslie's name out, who also represents Mr. Reynolds, to plant negative and completely fabricated and false stories with media, even prior to any marketing had commenced for the film, which was another reason why Wayfarer Studios made the decision to hire a crisis professional to commence internal scenario planning in the case they needed to address. The representatives of Wayfarer Studios still did nothing proactive nor retaliated and only responded to incoming media inquiries to ensure balanced and factual reporting and monitored social activity. What is pointedly missing, this is another big juicy thing she should have jumped on, from the cherry-picked correspondence is the evidence that there was no proactive measures taken with media or otherwise. So she made that statement as if it were fact that there was, and he's like, there wasn't. Just internal scenario planning and private correspondence to strategize, which is standard operating procedure with public relations professionals. So that was the entirety of his statement, and she chopped it up to where you can't even recognize the point or the meaning behind his statement. And this video, the video is even worse. This is the transcript of the video. Look how it starts. This is its introduction. The movie It Ends With Us, starring Blake Lively, was a huge box office hit, even as rumors spread of turmoil behind the scenes. In a legal complaint Lively filed on Friday, text messages and other documents that we've obtained. So other documents, again, an absolute admittance to this, reveal what really happened. That is not just reporting what's in a judicial document. This is her looking at the evidence, coming to a conclusion, and testifying to it. She's going to tell us what really happened. She can say what Blake Lively alleges really happened. She cannot say, we've obtained this stuff and we're going to tell you what really happened. Absolutely sickening. Back to this again, that admission of other documents that we've obtained. Obtained from where? Not from a courthouse, not from a public docket. Well, this is the more of the transcript. Sorry. She's stating it as absolute fact. At the same time, Nathan assembled a team that could dominate social media through full social account takedowns. By starting threads of theory, where's the proof of a full social account takedown? By starting threads of theories and generally working to change the narrative, it's impossible to know how much they planted and how much of it was originating organically. Whatever the case, they seized on it and amplified it. Really? Really, Megan? If these were public documents that you had the right to talk about, why aren't there pictures of them here? Why isn't there a link to the docket where we can go look at them? That's what we normally see in a newspaper article about a legal proceeding. We see the whole PDF embedded in the article, or we have a link to the docket to look at the article. None of that is here. Why? Because she can't. Now here is where, this is where I get so mad at the injustice of what's happened in this case. Because in Judge Lyman's order, where he granted the New York Times their motion to dismiss, he applied a case called Kinsey. This is a big deal in New York. It's pretty new, pretty recent. It was a New York Times case. It was Kinsey versus the New York Times. It was a defamation case as well, and it ended up going up to the Second Circuit Court of Appeals. This man lived in Washington, D.C. Or not lived. He lived in Maryland. He lived across the border, but he worked in Washington, D.C. His entire reputation was in Washington, D.C. He was a political figure. He was in the Department of Justice. He was high level. After he was married, after work, several of them went to a bar. They had some drinks. He apparently was accused of groping an intern. She had previously worked directly under him. She no longer worked directly under him. She worked under someone else now, but she was an intern and he was a high-level person and he was married and he groped her. In the article, the New York Times revealed an interview of someone who said that it was non-consensual. He said it was consensual and that saying that it was non-consensual was defamation. Because what is non-consensual groping It's assault. So he's like, okay, I did this, but you've got this part wrong, and this is defamation. You have destroyed my character. And he wanted choice of law to be in Washington, D.C., because that is where the event occurred. That is, like I said, where he worked. That is where he was known. And normally, in every other place in this country but New York, the person who was harmed, the plaintiff, gets to they have more weight to determine choice of law, because where is that harm mostly felt? It's felt where people know you. So, for example, I've mentioned this before in a case I also cover, a Buster I haven't covered in a while, but Buster Murdaugh. He is suing for defamation because some documentaries came out and they alluded to a rumor that ran rampant back in South Carolina, was that he was responsible for the murder of a boy by the name of Stephen Smith. Well, he was a man, but um and those documentaries did not handle well how they reported that. They made it seem as if it was possible that it was him, rather than put the full story that it was a rumor, and an unverified rumor. It was also, there was a newspaper man who was local, who was interviewed on these documentaries. He wrote about things extensively in his own newspaper that was local. So choice of law became a big thing because Buster is suing Netflix. He's suing Warner Brothers. He's suing a huge newspaper company that the local newspaper is owned by. And these people are from all over. There's other defendants as well. And so he wanted it to be in his local court. Well, that can't happen. It becomes a federal case by necessity because of jurisdiction. These people are not from where he's from. They're from all over the place. And so it got removed to federal court, just like this case did. He fought and fought to get it back to Hampton County, where he was from. And it just became this big deal, and it got split. It ended up with some of it going back to Hampton County and some of it remaining in federal court. But a big thing was about choice of law. And one of the things that was determined by that judge was that because he was the plaintiff, he was the one that suffered the reputational harm. It happened, he lives in South Carolina. So that's where people see him. That's where people know him. That's where he will be faced with people like he's already been faced, sitting in a restaurant or in a bar and people saying, oh, that's Buster, and talking loudly where he can hear it. So here's the thing. That's where he's going to feel the harm. And so that's what the judge ruled. Choice of law should go to that because he is the plaintiff. He's the one going to feel the harm. The harm is going to be felt in South Carolina. But New York has this case, Kinsey, that does away with that. They can force New York choice of law on anyone by saying they have a bigger interest. They have the interest of protecting the New York Times. Forget about the harm caused to the actual defamation victim, whoever they may be. Doesn't matter. We win. We're more important. And it's so stupid because that man doesn't live in New York. He doesn't work in New York. He doesn't go to New York. If people in New York are talking about him, it doesn't matter. What matters is the harm where he's actually going to be talked about, recognized, where he's going to feel the humiliation of the defamation. But that's the case, Kinsey. So that's what it's about. And of course, Judge Lyman used this case to say that the New York Times comes under New York choice of law. And under New York choice of law, they have this outrageously protected standard. And so he stayed the discovery. Wayfarer didn't get a chance to get one single piece of evidence to try to prove their case. And to me, it was of the utmost importance because of Van Zandt. Did the New York Times know about it? Did they advise her? Did she come to them with all of this contents of Jen Abel's phone and say, I want to print this story? Did they say, how did you get that stuff? That needs a subpoena. We don't know. We didn't get to find out. We don't know what the New York Times was given that was part of a CRD complaint and what they were given that was beyond the CRD complaint. Those facts are very, very important. And they were robbed of the chance because of this New York law. The case got dismissed before they even got a chance to prove whether or not they had a legitimate claim, and before the New York Times got to prove whether or not they actually fell under this privilege. Because it would all of the proof, none of it was allowed. So it got dismissed under New York choice of law. But the interesting bit is that this piece right here is also from Kinsey. So he used Kinsey to say it's New York choice of law while completely ignoring what Kinsey says right here about the actual defamation and what the privilege covers. He didn't apply this because if he had, it wouldn't have been dismissed. We've just gone through parts of the article. We've gone through parts of the transcript. You saw Megan's language. She was testifying. She was not presenting something as neutral report on a judicial proceeding by any stretch of the imagination. There were several things she presented as facts that she got factually wrong. Those two things are very important, and we're going to see why right here. A statement comes within the privilege and is deemed a fair and true report if it is substantially accurate. That as if, despite minor inaccuracy, it does not produce a different effect on a reader than would a report containing the precise truth. Look at that. Look at that sentence. This is binding authority in his circuit. This is the standard that this case should have been approached with, and it would not have been dismissed. Because guess what, chicken butts? Usually, when judges are trying to determine something like this, they have to hypothesize. They have to sit there and say, what would an objective, reasonable person conclude if such and so happened? But he doesn't even have to hypothesize. He doesn't have to guess. He doesn't have to wonder. He doesn't have to ponder. He doesn't have to muse. Because why? There are thousands of us that talk about this constantly. What's the question? Would a reader come to would it produce a different effect on a reader if we read a report containing the precise truth? What have so many of us said? We read this, we heard this, we said, oh, poor Blake, oh, disgusting Justin, based on what we read. That was the effect that it produced on us as readers. And what do we say now that we saw Justin's complaint, his counter complaint? And now, especially after seeing the great unsealing containing the precise truth, did we change? Did it produce a different effect on us as readers? Absolutely. And that is an undeniable fact, because from the time that counterclaim was put out by Wayfarer, what happened? We changed our minds. We stopped supporting Blake. We started supporting Wayfarer. How much more proof do you need to prove this sentence right here? This is the standard. This is binding authority that he needed to pay attention to and use to decide this. And there was already, at the time that he granted that motion to dismiss, there was already thousands and thousands and thousands of us out there saying exactly this. We believed Blake. We saw the proof. We changed our mind. And why did we believe Blake? We believed Blake because of Megan Twohey and the New York Times. It says right here, it comes within privilege if, but it fails this if in a huge way. And there is just completely factual evidence to that. All of us who've said openly for over a year that this happened to us, in fact, that we believed it until we saw the truth. What better evidence? You don't have to sit there and go, what would a reasonable, objective person say? You have thousands of us. A key test courts have adopted to resolve whether a report qualifies for the fair report privilege is whether the ordinary viewer or reader, this is what I'm talking about, can determine from the publication itself that the publication is reporting on a judicial proceeding. What did we gather from the way Megan wrote this article? We're readers. Does it sound to us like she's reporting on a judicial proceeding, or is she telling us, I've read all of this, I've seen all of this, we've gathered all of this, and this is what happened? She literally says what really happened. She literally says the texts show. You don't have to sit here and wonder what an ordinary viewer might think. We've been telling you for over a year. And we don't think that it looks like reporting on a judicial proceeding. We have been screaming about thousands of pages of texts and emails for over a year. This thumbnail is from an article, or not an article, it's from a video I did over 10 months ago when I was talking about this very thing, that she stepped outside of privilege. This is what I said almost a year ago. She stepped outside of privilege by talking about thousands of pages of texts and emails that were not part of any legal document. That all the mentions she said of other documents and things that they were able to have available to them. You don't have to wonder, Judge Lyman, whether an ordinary viewer or reader would determine that. We have been telling you. How did you miss this? How did you grant that motion to dismiss? I want to know. How can you justify that when you're faced with this binding authority that tells you what you're supposed to base a decision like that on? In other words, if the context in which the statement is made makes it impossible for the ordinary viewer or reader to determine whether the publication was reporting on a judicial proceeding, what does it say? The absolute privilege does not apply. We're here to tell you, Judge Lyman, it is impossible for us to see whether or not this publication was reported on a judicial proceeding. But in fact, now we know because of the great unsealing. And you denied Wayfarer justice. Absolutely denied. You didn't even let them try to prove their case, to try to prove these things. How are they ever going to meet this standard? What is the point of putting a standard like this in a document, in a court's order? What is the point if you're not going to give people the chance to even try to prove this? What is the point? Just sit there and say, we don't let you sue the New York Times in our state and leave it at that. Don't give us this kind of stuff if you're not going to follow it. So there's no point in it even being here because you don't follow it. This case should not have been dismissed for all of these reasons right here that I've talked about today, in my opinion. And I hope with all of my heart that they appeal it. Now, here's the thing. I would love to see this case go all the way up to the United States Supreme Court because something needs to change in New York. But as I said, the U.S. Supreme Court does not take on cases that are based on the idea of something is wrong with the state's laws. They don't do that. They're separate. They're federal. They're over federal. The only time they get involved in a state's laws is if it directly affects something federal, something to do with the Constitution. So time and again, people have taken cases like this and tried to, they've written petitions to the U.S. Supreme Court, and the Supreme Court denies it because they say states have their own sovereignty, they have their own constitutions, they have their own laws, they have every right to do this, and that the First Amendment is a very powerful protection. So I have been beside myself because I feel like, even though this standard says it right here, that if Wayfarer does appeal to the Second Circuit, where this is a Second Circuit decision right here, where they have made this decision, even if Wayfarer takes it and they say, according to your own standard, blah, 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 I feel like the Second Circuit is just going to say, nope, they're going to find a reason to just deny it. And that's it. That's it for them. Unless they could take it to the U.S. Supreme Court. So I was like, by golly, I'm going to find a way that this could go to the U.S. Supreme Court. And that's what I've been working on. And part of the reason I was disappeared. And I will get that to you once I get that completely done. It is not yet completely done, but this is just absolutely wrong to me. And I, with all of my heart, I want to see this fixed, not just for Wayfarer, but for all of the people. There is no reason that in one state, the citizens of that state, and now with Kinsey, they have moved to this privilege everywhere, that the rights given to one newspaper should be more important than the rights of people who have been injured by that newspaper. It needs to change. It's not fair. It is not just. It is not equal. And how are their rights more important than everyone else's right? And now I'm all sweaty. Thank you guys for sticking with me through that. It ended up being much longer than I expected it to be, but that's what happens when once I get going on something. Then my poor husband has heard me hollering about this for days because I wanted to get it just right for you guys. But anyway, so sorry, I've been ignoring the chat all along. And I told you at the end that I would love to hear from you and have just a moment to chat. I don't want to spend too long because, like I said, when I get too long, then people don't pay attention to them or come watch them. And I feel like this is a very important message. And that might sound a little egotistical of me, but I would like it to be seen, this one, because I think it's so important. But Daphne, you're absolutely 100% correct. Currently, the New York Times is untouchable, and you were right. It's unfair and it's unjust. Yep. Yeah, Cassidy got the sweats. I did. You don't know how many times after my lives I got to go take a shower. Oh goodness, but yeah, and I can't even do that tonight because I had those procedures done, and so I got to wait 24 hours. But anyway, yeah, my I think I told you guys because I had the one like really bad mole thing was removed, and so they did a whole body scan and they found 3 more that were questionable, and they tested those and they were not
they were just precancer. One was mild, two were moderate, but once that came back, they wanted to take, because of the other one, they wanted to take a little bit more off just to make sure. So I finally got that done today. So I can't shower for 24 hours. But yeah, that's a good idea, Christina. Use a washcloth to a bird bath, I guess. But Aunt Clara says, Cassidy feel exactly the same. My husband has learned to listen a bit, then walks away. He knows it can go on and on. I think my husband wants to, but he doesn't. He's very supportive. But so did anybody have any questions about this or anything you want me to specifically put into part 2? Then I am absolutely exhausted. It's been a super, super long day, a difficult day, and the numbing has worn off. So it's not going to be an easy night. New York Post is corrupt in my experience. Oh, the New York Post as well as the Times, huh? Well, anything in New York, here's the thing. Humans in general, not all of us, but humans, if you give them absolute power, expect the worst. The only way that you can, I mean, if laws were made and there was no consequence to breaking them, they would be broken constantly. I mean, even simple things like there are speed limits out there. And we a lot of times ignore those, but until we see a police officer, or our GPS alerts us that someone reported there's police up ahead, and then we're like, oh, what's my speed? It's just the way we unfortunately are in all our imperfection. And so when you in any nothing should be absolute, because it will breed this sort of situation, and it always ends in harm to somebody. Daphne says, hey, you still went long and it wasn't the chat's fault. Yep, I can't blame you guys. But as always, very informative and love the passion. Husband, give her some tea. Thoughts to you and your mom. Lots of love. Thank you. He did. I just forgot to drink it. Or I just took one drink break. We've been married almost 40 years. He's worn down. SS Webb says, my husband asked why I care about the case, and I start explaining, and he completely zones out. Exactly. Why ask? Why ask if you don't want to know? We care. Because it's not just about this case, it's about so much more. Really. Ah, that's why. Pam says Ronan Farrow is the Post, and he's buddies with Chewie. Yeah. And possibly involved in this, right? I've heard rumors about that. And in case you're wondering, Megan, that's how you phrase something when you're not sure. Okay? I didn't sit here and say Ronan Farrow teamed up with Megan Toohey, did I? That's how it's done. Yeah, I remember that somebody saying that he met with Taylor Swift, but I don't know if there's any like substantial proof to what that was all about. Aunt Clara says, I think YouTube's messing with this channel. Yeah. I've had a lot of weird things happen, and things being reported and crazy stuff like that. So um what? Someone else said that. They tried to hype and they weren't allowed, and even though they hadn't used any. They had some available, but they weren't given the option to hype my channel. Yep. Interesting. All right, guys. I think I'm gonna have to. Oh, is that what it is, Christina? Christina says you can hype once the live is open. Yeah, when I use it, I'm usually late to the game, and it's the live is already over. Okay, thanks, Pam. Pam backed that up. Okay. Lori said, my husband says, why do you put yourself through this? I know. Sometimes I ask myself that, and then I remember, I see something, and it's like, this is why. This is why. All right, guys, it's so super late. It's almost 12:30 my time, and so thank you so much for sticking it out with me and being so absolutely wonderful. Like I've said so many times, it's not just what the creators do, it's not just what the attorneys do, it's all of the supporters that get this word out there by showing up and by posting about it on your social media and encouraging us to keep going, really and truly. And I thank you guys from the bottom of my heart so much. I don't know that I would have done this much without all of you being so absolutely wonderful. So thank you guys oh so much. And Christina, thank you so much again for modding. And thank you, chat, for making Christina's job easy by being absolutely wonderful, sweet little darlings that I just absolutely adore. Anyway, have a good night, and I will see you soon. I will be back in my piles and piles of paper. Good night.